Dr. Tan Woo Meng.
Mr. Speaker, the Ministry of Health does not track such data. However, we are aware of a few cases where medical providers have conveyed information that may have led patients into thinking that their medical bill would qualify for panel benefits or be fully covered by insurance. Affected patients are encouraged to resolve their concerns directly with the medical provider first, failing which they may consider filing their dispute with the Clinical Claims Resolution Process, CCRP, which helps to resolve clinical matters pertaining to the Integrated Shield Plan, IP claims, or seek mediation with the healthcare institutions facilitated by MOH Holdings' Healthcare Mediation Unit.
Dr. Tan.
I thank MOH for the answer. I've got two supplementary questions. As illustration, I have a Clementi resident who sought treatment at a private hospital. The hospital website at the material time said that doctor and that doctor's clinic were covered on that insurance company's panel. The doctor affirmed that it would be covered on the insurance company's panel. After the treatment, the insurance company said it wasn't covered and it wasn't on the panel. Yet 6 months later, my resident showed me on my resident's handphone that the private hospital still reflected that doctor and that clinic as being on panel. When my resident appealed to MAS, they recommended he contact the insurance company. When my resident appealed to MOH, he was referred back to the doctor and the insurance firm. In the meantime, the private hospital sent debt collectors after my resident. Can I ask the ministry, who can consumers best seek help from in these situations? Is there a no wrong door policy to guide consumers? Because consumers sometimes worry whether every door seems the wrong one in such situations. Secondly, can I also ask, what recourse is there if the hospital provided outdated information, the consumer acted on the outdated information, and thereby suffered financial disadvantage? Are there lessons which can be learned from the Consumer Protection Fair Trading Act regime and CCCS and MTI that could be applied to this as well? Thank you.
SPS Rahayu.
Tan for sharing his resident's situation and for raising the supplementary questions. I can appreciate his concern in this case. The member had asked about the agency to refer to and the recourse available to the consumers. For disputes involving miscommunication between the patients, the medical providers, the patients may consider writing in to MOH Holdings Healthcare Mediation Unit for mediation services if they are not able to resolve the matter with the provider. And if they are then still not able to resolve that through mediation, the other possible avenues includes recourse through the Consumers Association of Singapore case, as well as the Small Claims Tribunal. The case that Dr. Tan had surfaced is indeed an unfortunate one. It is a situation where there was a misunderstanding on the doctor's part and also a miscommunication on the hospital's part. This is actually a good opportunity to remind all the stakeholders to play their part in helping patients to make informed decisions about their panel benefits. The hospitals that wish to actually inform patients of the doctor's panel status should ensure that the information that they've provided is actually updated, and the doctors should also inform patients of any changes in their panel status as soon as possible. The insurers and their agents should also remind policyholders to check first the panel status of the doctor before going for the treatment and explain the implications of their insurance coverage. Here in this situation, actually, when everyone plays a part, situations like this could be avoided. So I appreciate the members' concerns, but in this case, it was really one of those few cases that we've seen where there was a misunderstanding and miscommunication. If everybody had followed according to what they were supposed to have done, this situation could indeed have been prevented.